Hello, friends. This is not legal advice. Every case is different, and if you have a legal issue, reach out to an attorney. Like me. Adjusters, if you need a great workers' compensation defense attorney, my contact is in the description. Today, we are discussing Daubert. Let me speak English for a second, because what is Daubert? Daubert comes up when expert opinions are flawed. How can an expert opinion be flawed? The short and sweet of it is this. If you hire a doctor, give him all of the records. Before we dive into the story, I want to quickly go over the 3 rules for Daubert. We are looking at the Florida Evidence Code for 2 seconds. I know this is super boring, but it's very, very important for this final hearing. For us to analyze this final hearing, we need to understand this. It's going to take 2 seconds, okay? We are looking at testimony by expert. An expert may testify if the testimony is based on sufficient facts and data. Did you tell your doctor everything that you needed to tell him about the situation? The testimony is the product of reliable principles and methods. Is this just his opinion on how things worked? Or is he using published standards and practices? And did the witness apply those facts and that data to those reliable principles and methods? Okay, let's get out of the statute, but I want to make something clear. Today, the important part of this statute is what is highlighted right now. You have to give the doctor all of the information. David Lorenzo versus Sam's Club. I also want to mention that this document is public record. I encourage you to go to the case search tool on OJCC's website and put in the case number. It's all right there. Here's what the final order says. David Lorenzo is a 34-year-old diabetic. He worked in the tree trimming industry for his entire post-high school life until in June 2020, he started working at Sam's Club. He worked at Sam's Club as a merchandiser. He was lifting up heavy things and moving them around. But let's talk about before June 2020, before he started working for Sam's Club. What happened before that? March 2017, after a motor vehicle accident, he goes to a hospital complaining of tingling in his neck. He's diagnosed with a cervical sprain. May 2017, another hospital visit, this time complaining of tingling in his back. April of 2018, right arm and right shoulder pain, tingling. And in February 2020, he visits a hospital complaining of left arm and face numbness, tingling, and pain. Remember, all of this is before Sam's Club. On September 9th, after about 3 months of working at Sam's Club, he approaches his boss and says, "Hey, I feel dizzy, I feel weak, I think my diabetes is acting up." David said nothing about neck or shoulder pain. The next day, he goes to a hospital where he's complaining of left arm tingling. And actually, in that record, it says something about how the complaints were similar to his February 2020 visit. David files a workers' compensation claim. The employer denies the claim in full. The employer obtains a doctor to render his MCC determination. The claimant does the same exact thing. The employer's doctor says the issues are pre-existing and do not have to do with his job. The claimant's doctor says the opposite, but there were some big problems with the opinion of the claimant's doctor, which I'm gonna get into right now. Okay, here are the things that the claimant's doctor did not know before rendering his opinion. Okay, here we go. This is the list. This is in the final order. These are the things that the claimant's doctor did not consider, okay? Okay, remember, the claimant's doctor needs to figure out if the issues are pre-existing, okay? So we're gonna look at that right now. These are the things that the claimant's doctor did not know. Dr. Smith was not aware of claimant's prior neck and shoulder problems. Claimant vaguely mentioned to Dr. Smith that he had a left shoulder injury about a year prior while working for a tree company. However, Dr. Smith did not have any further information about that. Dr. Smith was unaware of the March 2017 motor vehicle accident where the claimant complained of neck pain. Dr. Smith did not know about the February 2020 hospital visit where the claimant was complaining about things that were extremely similar to things that he was complaining about at the September 2020 hospital visit. Apparently, the doctor also didn't know how heavy the items were that the claimant was lifting and moving around while at work. The doctor didn't know how often he had to move things around or what the items even were. Dr. Smith thought that these complaints started on September 9th, 2020, when clear evidence on the record showed that he was complaining of similar things previously. How is this possible? Every IME that I have ever handled has been given every single piece of medical paperwork that I have at my disposal, and I have prepared them by having long conversations about what is in those medical records, specifically the things that I need them to know. If there are prior complaints of the same thing, the doctor needs to be aware of that, right? So I'm not saying that, I mean, I don't know how this happens. It seems like some sort of miscommunication between the doctor and the law. I mean, I don't know. I wasn't there for conversations or lack thereof of conversations. I don't know what happened. All I know is that this doctor, for some reason, was not given information about the claimant's history of the same exact issues that he was complaining of. I don't know how that happens. Somehow it gets even worse. And I hope you're starting to see why this... Oh, wait, hold on. why this prong is so relevant to this case. During the doctor's deposition, the doctor confirmed that he had not been given any medical records prior to the date of the accident, which was September 9th, 2020. He even indicated the following. I'm going to read this for you. When asked exactly what he would need in order to change his opinion on causation, Dr. Smith stated, "It would be the medical records showing that Mr. Lorenzo was complaining of his neck and shoulder and numbness and burning in his left arm prior to the beginning of his employment with Sam's Club," which is exactly what the February 2020 records show. That was during the deposition of the doctor. Now, it seems like the doctor may have also testified at the final hearing. Now, in between that deposition and that final hearing, it seems that the doctor had time to review the records. It seems that the claimant's attorney should have sent those records to the doctor. Well, the judge gave the claimant's attorney a chance to cure that doctor's testimony. Somehow, this happened. At the final hearing, the doctor was still under the impression that the claimant had not complained of similar issues before the date of the accident. Like, how is there this much miscommunication between the attorney and the doctor? I don't understand how that could even happen. It seems like he just wasn't aware of them. It seems like he just never received these records. I really don't know how this happens. So the judge decided that the deficiencies in his testimony couldn't be cured. The doctor's testimony was not based off of sufficient facts. It seems like the doctor was never provided with the facts. So the judge decided that the testimony of the claimant's doctor was not reliable. Now, I want to take a quick look at the forest through the trees, okay? What's the point of all this? Why all these doctors? Why does the employer have a doctor? Why does the claimant have a doctor? It's because the claimant wants to create a conflict, so the judge appoints his doctor, and that judge's doctor makes the final decision. The job that the claimant's counsel really wanted to complete was to create that conflict. So the judge found no competent substantial evidence of a conflict, so the judge went with the employer's doctor. The judge accepted that the issues were pre-existing and denied all claims. Now, Daubert doesn't stop there. There's a lot more to Daubert, specifically when it comes to how opinions are made. Obviously, an expert needs all the facts and the data, but what methods is the doctor using to analyze those facts and data? Well, I'm sure we're going to analyze that some other time. Thank you so much for watching this video. My name is Levi Graham Weinstein. I'm a workers' compensation defense attorney. And if you are a workers' compensation adjuster, my contact is in the description. Send me your work. Let's represent some employers.